Hey, how you doing today, everybody? We're here today. I'm here to do a real quick video, kind of about Brendan's oral arguments today. I went ahead and cherry picked some of the best bits, in my opinion, to put them together in one video here. Hopefully, a real short one. And I'm gonna do less talking in between and just let the clips kind of do the talking for themselves. But I will interject a few of my own thoughts. We're gonna go into the first clip here, which is, by the way, you got 3 judges. You got Ilana D. Rovner, you got Ann C. Williams, and you've got David F. Hamilton. Those are the 3 judges. And the person arguing for the state of Wisconsin his last name is Berg, and he's referred to as Berg in the audio. So, anyways, the first thing here you're going to see is that he is asked a question about offers or promises of leniency or vague promises of leniency and stuff like that, and he gives his answer and everything, and eventually culminates all into this explanation but he was read his Miranda warning, so all of these vague or unclear promises are irrelevant because the Miranda warning was said once or twice, and this judge is trying to hammer home to him. But even when it's said 20 or 30 or 40 times, anyway, so I'll let you see that here, and then we'll come on back.
Help me with this. If a police officer says to someone who is being interrogated, let's get it all out today and this will be all over, I have a 2-part question for you. The first part is, what would the average person think this means? Would that person think, I can go home? It's done. Now, the second part of the question is, I want you to imagine it is not an average person, but a 16-year-old with a very, very low IQ who is extremely suggestible. And I would very much like you to concentrate on the suggestible.
I think neither an average person nor Dassey would interpret that statement as meaning that he could go home.
What if there were 20 such statements, 30 such statements?
There are multiple reasons why none of those statements communicated to Dassey that he could leave. Number 1, nothing the investigators said actually promised a specific benefit in exchange for cooperation. Courts consistently reject false promise theories where there hasn't been a very specific offer. Second, the only specific things the officers said were warnings. They said, we can't make you any promises, and anything you say can be used against you. Those warnings were there to prevent Dassey from misinterpreting anything else that the officers said.
So in this next bit, you're going to see where I believe it's Judge Williams, Ann Williams, that is she's kind of grilling Berg a bit. She's kind of grilling him about what constitutes a lie or what constitutes a false promise or a false statement. And she's bringing up the fact that they would, say don't lie or whatever. And then, or that they were getting very frustrated with him when he was, not guessing what they wanted, and so she's kind of grilling him here, and it's kind of fun to watch. It's kind of well listened to anyway. So I'll go ahead and play that one here.
The officer said we're cops, we're investigators, and stuff like that. But right now, I'm a father that has a kid your age too. I wish I could hug you, and I will not leave you high and dry. Do you think those untruths cross the line?
No, not at all.
Oh, in other words, I'm not a cop right now. Isn't that just a blatant lie?
This was an interview. The context is very important. So the difference between an interview and interrogation is crucial. When the officers went into the interview, they assumed that Dassey was simply a witness, and they communicated this to him the first time that they talked to him on February 27th. They said, there are some officers that think maybe you helped Avery participate. We don't think you did participate. We think maybe you saw some things, but we think you weren't involved. So their statements must be understood in that light. They thought he was a witness, and they told him that.
So your position is that each of these incidents are segregated and finite and distinct, and that he would not still remember those statements that they were acting as a father?
I'm not sure I understand the question.
Well, the different sessions. You're saying that in February 27th, when he said they were acting as officers, but as fathers, and you're saying that then he was just being interviewed as a witness. And so, are you saying then that ended at the next session, that wouldn't carry over at all to the next session?
No, that was still true at the March 1st interview. They still thought he was a witness at that point and that he hadn't participated. And so
this aura, what I'm trying to get at is this aura suggesting that they were fathers is something that just didn't dissipate.
The idea that they thought he was a witness didn't dissipate, so all of their statements of "it's okay, we're on your side," that must all be understood in the context of what they thought, because they communicated that.
Well, how did the investigators not act coercively when they clearly showed frustration when he resisted or disagreed with key details and then offered praise such as, "Now we believe you"?
Okay, so, yeah. And, I mean, are you kidding me? Questioning him as a witness only. Yeah, no. They fully figured out on February 27th or 26th that they could easily lead him down a path and then planned for the March 1st event. But anyways, so then this next bit, it's going to move on where Judge Dassey Williams is asking him about, well, basically she starts out telling him that juvenile cases of juvenile coercion require special care according to Supreme Court case and ruling and whatever. So she says to him, why does it seem like this wasn't given special care in the appellate court? And to which he answers that the appellate court basically agreed with the state court that the state court had given a great deal of consideration and care to the age of Brendan Dassey. It's that's basically what he says. So that he's basically but you can tell that these judges have an issue with the fact that the appeals court didn't really look into it much. Didn't really take, at least you can tell that this judge has an issue with it. And she then goes on to the fact that she goes, okay, fine, let's talk about Luchinsky then, and his investigator. And she basically is like, she actually says in these words of, who are basically acting as though it's their duty to get him to confess, and all that. And so after saying that to him, he comes back with something he does a lot throughout this whole thing, and I'm not sure how these judges are going to feel about it. I think these judges might have a little bit of a problem with him because he numerous times he reminds them that this is habeas, that this is a habeas, a writ of habeas corpus appeal, and that in that case you can only use clearly established case law. I mean, he reminds them of this multiple times, like I'd say probably like at least 6 to 8 times he says this. Now, it's his right, of course, to do that, but yeah, I don't know if you want to be reminding judges of something like that, like if they're stupid that many times. But anyways, so that's just my thoughts on it, but we'll go ahead and move into the next clip here so you can see it.
But first, you agree that age is a relevant factor in determining whether confession is voluntary.
I do, but
and the Supreme Court said in Gall and other cases that juvenile confessions must be evaluated with special care. So I want to know exactly where the Wisconsin Appellate Court decision says or considers Dassey's age and where it was given special care.
Dassey's age is listed in the opinion.
Yeah, it's listed, but in special care is more than just listing, don't you think?
The Wisconsin Court of Appeals opinion was also based on the trial court's finding, and that was a lot more explicit about Dassey's age.
And exactly what was said that the appellate court made reference to in their decision. In terms of the trial court, I'm just saying listing the factor doesn't necessarily mean special care.
There's no evidence that it did not consider age. It clearly was aware of age. It mentioned it. This court in Carter said, we're never going to review a state court opinion simply because it lists a factor in the facts section of its opinion and doesn't read it in the analysis. So on habeas, you can't assume that the Court of Appeals didn't consider age. It clearly was aware of age. It said it was basing its opinion on the trial court's decision, and the trial court's decision spent a lot of time on age. So I think on habeas especially, you can't assume that the Wisconsin Court of Appeals did not consider age.
Apply. I mean, it's clear that Kaczynski and his investigators saw it as their duty to get him to confess, so that that confession could be used against Stephen Avery.
It's important to remember we're on habeas here. It's important to remember that we're on habeas review here. All that matters is clearly established Supreme Court.
Okay, so now we're going to see where Judge Hamilton asks Berg a question. He asks him about whether or not there is documentation of what facts were given in the media prior to Brendan's arrest, to which he answers that he doesn't really know. He doesn't know if there's ever been a compilation or a record created of those media facts that were, like I said, out before Brendan was, or were broadcast before Brendan was arrested. And he doesn't have the answer. So what I'm going to show you here is that bit, and then I'm going to show you the bit. It's going to be the real quick opening bit of Laura Nyrider, where you can see she goes ahead and takes it upon herself to go ahead and answer that question for Judge Hamilton, which I think is funny because Judge Hamilton is clearly the judge here that thinks that, there's nothing, that there's very little wrong with this confession. And so she automatically, first thing she does on her end is she goes, oh yes, and Judge Hamilton, yes, that information you're looking for is in the appendix of the district court's review of the case, and blah blah blah. So I just thought that was funny. I just thought it was funny. So I'm going to show you guys that here, and then we'll come back.
Could I go back to the confession for a moment? During the videotape confession, Mr. Dassey comes out with a lot of details that he supplies. The opposing side has explained that as details that had been publicized. I'm wondering if you have any response to that general point, and whether we have any record concerning which of those facts that he ultimately volunteered without suggestion might or might not have come from publicity.
I think there's a few minor points. So there's a few facts that we know had been released by the police officers, but the vast majority of them had not.
Do we have a record about that somewhere?
Not that I could find, no.
Okay.
Good morning, Your Honors. May it please the Court, Laura Nyrider for Petitioner Appellee Brendan Dassey. I'll start, if I may, with the voluntariness issue and then move to ineffective assistance of counsel. But before I do, Judge Hamilton, you'd asked a question about whether there was a record built on the media stories that had been in circulation prior to Brendan Dassey's confession. There was an extensive record built in state post-conviction proceedings that is referenced in the district court opinion in this case at RSA 69.
Okay, so now this next part is going to be Judge Hamilton asking Mr. Berg about the slashing of the throat and the rape. Now, the thing is that he in it says basically, like, he says, was there any evidence? Did they find any evidence? Or were they able to find any evidence of this on the body or whatever? To which Mr. Berg says, no, the body was completely destroyed. And then Judge Hamilton comes back with, so those facts came strictly from Brendan himself. Like if that's incriminating. But here's the problem, Judge Hamilton. How do you know it ever even happened? There's no proof that it even happened. So how can you use something that there's no proof that it even happened as corroborating evidence in the confession? Anyways, I'm not a judge and I'm not a lawyer, but just seems a little bit odd to me. But anyways, so we'll move it. And then when they go on to, then Judge Hamilton actually has a little bit of an issue with the appellate court's decision or opinion, because he kind of doesn't dig the way that they say that there was no promises of leniency. Clearly, Judge Hamilton is not prepared to say that there was no promises of leniency. But he is willing to minimize it by saying that they were vague promises of leniency. So I don't know. I don't see where he, I don't see the distinction really. I mean, especially when Brendan was, how does you'll see here Laura Nyrider put it later, the drum beat, the litany drum beat of them, just coaxing him and doing all the things, and telling him not to tell the truth and all those sort of things that they were doing. So so basically Judge Hamilton is basically questioning this opinion of the appellate court and asking Mr. Berg about it. So we'll go ahead and see that.
And then I also wanted to ask you, and I realize this gets fairly grisly given the condition of the body when it was discovered, but was there physical evidence of a rape or of the wound to the throat?
No, because the body was totally destroyed.
So those come only from Dassey's confession.
That's right. Yes. But
And
there
would
were
not have
two-
been publicized ahead of time.
That's right. Yes.
Okay. And with respect to the Wisconsin Court of Appeals opinion, we say the court, referring to the district court, the trial court, found that investigators used normal speaking tones. That's correct.
Right.
No hectoring. I think that's correct.
Right.
No threats.
Right.
That's correct. And they say no promises of leniency.
Right.
Now, obviously there were vague promises of leniency, right?
I think in context, no, there weren't even implications of leniency for two reasons. One, they went into the interview thinking that he was a witness, and they communicated that to him. Second, they thought, based on what Dassey told them, that to the extent he participated, Avery made him do it by threatening to stab him like he had stabbed Teresa. So their statements, it's not your fault, he made you do it, it's okay, a lot of those were premised on those two things. They thought he was a witness, and if he participated, he was forced into it.
Well, look, I think we all know that the police are allowed to induce confessions by some misdirection and deception.
Right.
In essence, out-and-out fraudulent promises, as in some extreme cases. This will be a confidential discussion, for example, just between us. Those kinds of things can cause problems. If the Wisconsin Court of Appeals had written no legally relevant promises of leniency, I think that would probably be accurate here. That's not quite what they said.
Well, I think that's clearly what they were referring to, and in any event, I think there weren't even implied promises of leniency. Even if there were specific warnings that contradicted any implications. We can't make any promises. They said that explicitly. And we have evidence that his will was not overborne. He resisted the officers multiple times. He volunteered many details. You can see his demeanor. So, no, I don't think there were even implied promises.
Okay, so now we're going to move into where, Berg is basically saying that there was no implied promises. And then one of the judges starts reading off a list of statements. And he listens to it, and then when she's done listing off those comments or statements or whatever, he just says, yes, but there was no implied promises there. He's just sticking to it, which I find odd because Judge Hamilton was just kind of addressing it, talking about the appellate court's opinion in that they should have said no legally significant promises were made or something to that effect, and almost like if you maybe got the impression that Hamilton was trying to suggest to Berg, like just acknowledge the fact that there's some vague promises here, but it looks like Berg is not having it. And I could be wrong. Hamilton may not have been trying to suggest that to him, but
to worry about. We're in your corner. We already know. Just tell us it's okay. We're going to help you through this. No matter what you did, we can work through it. It's okay as long as you can, as long as you be honest. If you lie about that, that's going to be problems. If you helped him, it's okay because he was telling you to do it. This will all be over with. Honesty is the only thing that will set you free. And I could go on. And
none of those statements are specific promises. That's what the cases require. They were directly contradicted by a statement. We can't make you any.
Okay, so now we're going to move into the segment where they're questioning Nyrider. You basically already heard her opening where she came up there and answered that question for Judge Hamilton. But now we're going to move into some other stuff here. The judge is asking her questions, dealing with some with case law, but mostly with points of logic. There's Judge Rovner is questioning about Len Kaczynski. And if they were able to get the May 13th confession thrown out or whatever, why weren't they able to get the phone call thrown out? And Laura goes through explaining that and stuff. So we'll go ahead and go into that, and we'll see you in a second.
But it's not important here whether they knew. The question of voluntariness is not a referendum on the state of mind of the officers. The question is, what message was sent to Brendan Dassey? And did it overbear his will? And when we have someone like Brendan with his slew of limitations, staggeringly suggestible, more suggestible than 95% of the population, a concrete thinker, the kind of person likely to interpret idioms like honesty will set you free, literally. The repeated drumbeat of messages that were sent to him clearly overbore his will.
And what about, look, I've watched the whole thing. I don't see a will being overborne. And what I see also are Miranda warnings. We can use this against you. And we can't make any promises, right?
They do say
so we've got all of that, and we've got vague promises about the benefits of being honest, right? And I don't see any case law comparable that would let us say this was contrary to clearly established federal law on voluntariness.
Well, Your Honor, several points. We have a D2. In fact, the district court granted its relief primarily on D2 grounds. So again, clearly established
on the
federal
statement
law.
That no promises of leniency were made.
On the finding of no promises, that's right.
Okay, now could you address the exchange I had with Mr. Berg about whether these are legally relevant promises when it's these vague assurances?
These are absolutely legally relevant promises, Your Honor. It's true that the case law requires a specific promise to be made, but if you survey the case law, you can see the difference between what has been approved by this court and what happened for Brendan Dassey in Rutledge.
So what's the best Supreme Court authority showing this was an unreasonable finding?
The best Supreme Court authority is Blackburn, which establishes that a confession has to be the product of rational choice. Keyword there being rational. That notion has been amplified by this court to mean the product of free will that has not been distorted by a false presentation of the consequences of confessing.
Was there any objection to the admission of the phone call to Brendan's mother in the trial court?
There was not, Your Honor, and there was a good reason for that. Mr. Kaczynski did not turn over the evidence related to the provenance of that call, including the videotape of Michael O'Kelly interrogating Brendan Dassey on May 12th. He did not produce that to successor counsel. So trial counsel was totally unaware of how that phone call had been brought about. That only came out in post-conviction proceedings.
If Kaczynski if his significantly deficient behavior was enough to get the May 13th interrogation thrown out, why wasn't it enough to get the phone call to Dassey's mother thrown out under a fruit of the poisonous tree argument?
If I understand you to be asking, Your Honor, why didn't trial counsel make that motion? It's precisely because they didn't know the pressures that Mr. Kaczynski and his investigator had applied to Brendan Dassey on May 12th. None of that had been turned over to them. They were in the dark. And at post-conviction was the first time that they confronted that series of facts, that series of events that in fact led up to the phone call. And they called the admission of that phone call damning. They understood that it was difficult, that it was a challenge for their case, but they didn't have the information they needed to make the proper motion to exclude it at the time as the fruit of ineffective assistance of counsel.
Let me ask you this. How are the investigators' statements that everything will be okay coercive or promises of leniency rather than simply false promises of net benefits?
Well, Your Honor, they didn't just say everything will be okay. They told him, they started out the whole interrogation, we know you're scared of arrest, but you've got nothing to worry about. As long as you fill in those blanks with statements against your own interests, I'm thinking you're all right. You're okay. That's enough For a 16-year-old developmentally disabled child like Brendan Dassey, that's enough to produce in him an understanding that he was going to go back to school after confessing to rape and murder, which is exactly what we see on the videotape. Unmistakable evidence that he confessed on reliance on these false promises.
All right, so now we're going to move into this next bit. It's just more questions from the judges and to Laura, and Laura answers them. I mean, she answers like a champ. She's got a very, astute answer for pretty much everything. So it's very interesting to listen to. But the thing that I want to draw to your attention here is Judge Hamilton, man. This guy, he's something else. He's sitting there, he interrupts her to tell her that, oh, I watched the entire confession. And then he asks her whatever, and then she starts talking, and then she starts talking about plot points. He's like, what plot points? What do you mean? What are you talking about? And she's just like, and so she explains what she means, and she starts talking again. And then she mentions fact feeding, and he's all, what's this fact feeding? What are you talking about? It's just like, dude, did you watch it? I thought you just said you watched it. Anyways, I just think it's funny. But anyways, go ahead and check this clip out.
Well, it's clear he's been very resistant up to that point. He's been very reluctant. He's telling a contradictory story that doesn't make any sense, and they're calling him on it. It comes out very slowly and painfully, but he volunteers it.
Your Honor, I would respectfully disagree.
Okay.
Every step of that confession, every new fact, every primary plot point is a result of suggestion. Now, it's true that after the interrogators introduce a plot point, they allow Brendan to embellish until the story veers from what they think probably happened, and then
plot
they
point
recenter.
like what? You
plot
went
point.
inside,
You went inside the house, yes.
and then
And
you're holding them responsible for all the details that come after that.
I'm not holding them responsible, Your Honor, but I'm pointing out that what happened was they used false promises of leniency combined with fact-feeding at every crucial step of the story.
What's the fact feeding? I guess I'm having trouble with that in the early stages of the interview.
Absolutely. I think you went over to Stephen Avery's house at Separate Appendix 54. You went back in that room, Separate Appendix 61. Does he ask you to rape Halbach, Separate Appendix at 60? You were there when she died, Separate Appendix 67. Step by step by step. Now, Your Honor is correct that this isn't sequential. This isn't over the course of 5 minutes. After they give him each step, they allow him to try to tell a story on his own. And what does he do in those moments? He provides information that is provably untrue. He describes, after they put him in the trailer, he describes looking down that hallway and seeing Ms. Halbach shackled to a wooden headboard. But that wooden headboard, we know, has no scratches on it, has no marks, nothing that would be consistent with this horrible story of a woman being raped while she was shackled to it. There's this whole account that they allow him to spin where he's trying to guess how she was killed. This account of throat cutting and stabbing and hair cutting, a bloody scene that would be almost impossible to clean up from. But there's not a trace of forensic evidence from Teresa Halbach in that bedroom, much less Brendan Dassey. So these moments where they're allowing him to spin on his own are provably untrue, or they are like clockwork from the media. It's when things begin to spin off the rails too much that they bring him back to the account.
What came from the media?
Many things, Your Honor. The fact that her RAV4 was found on the salvage yard property. The fact that she was there that day. The fact that her bones were found in the bonfire pit behind Stephen Avery's house. Many aspects like that, which many people in the state of Wisconsin knew. And of course, it was established in the state post-conviction record that, of course, Brendan and his family were watching the news about what was happening to their relative and to their home.
All right, so now we're going to move into a clip where we hear Miss Nyrider talking about the amicus brief. Yeah, good stuff. So here we go.
Because we know that to be factually untrue. In fact, we have an amicus brief exactly to that effect, establishing that false confessions happen under circumstances just like this to kids just like Brendan. They're textured. They can be textured with detail. There are examples in the amicus brief of cases like the Central Park 5, other famous cases where young defendants gave interlocking, detailed confessions that sounded true that were later proven false. So we know that We know that not to be true. And I would also point out that in the amicus brief, I think it speaks volumes that the law enforcement interrogation trainers who joined the amicus brief say they use this interrogation video as an example of what not.
All right, now we're going to move into the last clip where basically Laura Nyrider is pointing out some of the issues with Brendan's confession. Mainly that the things that he says aren't right. He says things that aren't accurate. Some of them are not even in the right ballpark. And what she's saying is that what the investigators do at that point is they rein him in a bit, and then they kind of, give him a little bit more teaching, or whatever. But that he eventually will change his story. So what she's getting at with this is she brings up the shooting Teresa in the head incident. She's telling the court that originally when they were questioning him about this, he said it all happened out by the bonfire. It all happened out by the fire pit. Well, we know that it eventually moved to the garage. So what they did is that when he was saying the fire pit, they eventually said, look, hey, Brendan, we know it was something with the garage. We know there was something going on with the garage, and, we really need you to tell us the truth, blah, 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 blah. And then suddenly Teresa got moved into the garage, getting shot in the head in the garage. So she's pointing out that this is not corroborating Brendan's story. This is corroborating investigators' story or claims, Anyways, it's really good. And, so go ahead and give it a listen here. This is the last clip, and then I'll come back and talk to you real brief.
Age was sufficient. You don't agree with that view.
I don't agree with that.
And because it made reference to the underlying trial court's finding that the court really didn't need to do anything more.
I don't agree with that view, Your Honor, particularly, again, with respect to the D2 violation here. We have a state trial court that found no promises of leniency. We have a Wisconsin appellate court that adopted that finding. And then, premised on that erroneous factual finding, they weighed the remaining factors, didn't sufficiently account for the fact that he is 16 years old, didn't address the way in which this message of leniency would be heard by a 16-year-old with developmental disabilities. There is no need when you have someone like Brendan Dassey. You don't have to make explicit statements like you're going to go to prison but for less time. You don't need to do that with someone like Brendan Dassey. It's enough to say everything is going to be okay. You have nothing to worry about.
Is there any physical evidence at all that ties Dassey to the murder?
That ties Dassey to the murder? No, Your Honor. There is nothing that did not come from the fact-feeding that occurred during this interrogation. I expect you'll hear the state suggest that he led them to a bullet in the garage. That's not the case. If you watch, as I'm sure Your Honor has, when you watch the videotape in this case, Brendan has the shooting at first happening outside by the bonfire pit. And the officers say to him, because they know, they've found 10 shell casings in that garage already. They say to him, no, Brendan, we know some things happened in that garage. We need to get the honesty about the garage. That's when he moves the murder into the garage. Then they research the garage and discover this bullet. That corroborates not Brendan Dassey's account, but the interrogator's account.
And the issue of her bag and phone and camera that were missing, that was provided by the investigators.
Absolutely, Your Honor. That's one of the classic examples in this interrogation of fact-feeding, a sequence of events in which they teach him the answer that they're looking for when he cannot come up with this information. They end up feeding him the specific facts. Her purse, her camera, her cell phone were in the burn barrel. Only then does he regurgitate it back. If there are no further questions, we would ask the district court, we would ask the Court of Appeals to affirm.
Okay, folks, so that's about it. It was pretty interesting, I think. I didn't even bother showing Berg's rebuttal because Berg's rebuttal was just regurgitation of everything he said in the first 5 or 10 minutes. Nothing new, nothing interesting really about what he was saying. I don't know. Anyways, it was just more repeating himself. And like I said, he was repeating himself a lot. particularly the thing that I think may work against him is the repeating of the fact that this is a habeas case. This is a habeas case. Only clearly established Supreme Court law applies. You know, like 3 judges want to be reminded by you 8 times of something they already know. So I don't know. I mean, it's his right to say it, and he obviously felt a need to, say it. But man, dude, okay, say it, but don't say it 8 times. But hey, whatever, he did it. I tend to think the judges are going to find it disrespectful, but maybe not. They may just think whatever. But just weird the way that guy kept repeating himself. But anyways, that's it. We'll see you guys later. If you haven't already, please hit subscribe.